Mr. Speaker, I rise today to speak to Bill C-25, the Qalipu Mi'kmaq First Nation Act. I think it's most important that we put this bill into perspective. We cannot lose sight of what the agreements behind this bill are attempting to redress. The legal rights of Newfoundland's Mi'kmaq people have been in limbo since their status under the Indian Act was left unresolved in 1949 when Newfoundland joined Confederation. Exclusion from status under the Indian Act not only denied Newfoundland's Mi'kmaq people access to supports available to other First Nations, but robbed them of recognition of their identity and cultural heritage. The prejudice caused
and the marginalization of many generations meant that many tried to hide their origins, and thus family histories have been lost for good.
Negotiations and protracted legal action over many governments meant this fundamental issue remained unresolved far too long. The most recent phase of discussions to redress the historic exclusion of status for Newfoundland's Mi'kmaq people began in 2002, when the previous Liberal government initiated renewed, good faith negotiations with the Federation of Newfoundland Indians. The talks focused on the recognition of the Mi'kmaq people in Newfoundland under the Indian Act, and after constructive discussions, an agreement in principle was signed in 2007. On September the 26th, 2007, the Prime Minister said, for more than half a century, the Mi'kmaq people of Newfoundland were among the, quote, forgotten people, end quote, as the Congress of Aboriginal Peoples calls its members. They never stopped fighting for recognition, and now, at last, that title can be cast aside. Ratified in 2008, the agreement would create the landless Qalipu Mi'kmaq First Nations Band and ensure that Mi'kmaq people in Newfoundland would be able to achieve recognition, status under the Indian Act, and the dignity denied to them for far too long. The
Liberal Party believes that any bill or any directive or policy implementing accords between the government and the Mi'kmaq Nation must rest on the premise that legitimate applicants must not be excluded from the process.
About the fact that, unfortunately, this bill seems more focused on protecting the federal government from being sued over their mistakes in how it implemented this historic agreement and limiting the legal recourse of membership applicants for the new First Nation. We understand that the government expected far fewer applications than the 103,000 they eventually received. But if the process was flawed, if the criteria or guidelines were problematic, then the fault lies with the Conservative government, not the applicants. It was the Conservative government that negotiated the criteria for enrollment and how those criteria would be administered. That process was set down in guidelines that were appended to the original agreement. Because of the greater than expected volume of applications, last year the government entered into a supplemental agreement with the Qalipu First Nation and the Federation of Newfoundland Indians. Pursuant to that supplemental agreement, the government is now in the process of reviewing all applicants, including those who have already been granted status. While the government asserts that the supplemental agreement does not change the membership criteria, it does change the guidelines for how those criteria are to be assessed. There is no question that these changes will potentially have an impact on enrollment, and that is why a review of all applications, including those that have already been granted, is underway. While Section 10 of the supplementary agreement affirms that it does not affect the status of the Qalipu Mi'kmaq First Nation Band, it could alter its founding members list. As a result, members who do not meet the additional enrollment criteria could lose their band membership and Indian status. The power of Cabinet to remove individuals from the founding members list is confirmed in Clause 3 of Bill C-25 and is one of two substantive things this bill does. The Liberal Party recognizes that both the 2008 agreement and last year's supplementary agreement flow from a nation-to-nation process that must be respected. The criteria negotiated between the parties should be viewed as an agreement between two nations. However, while the government claims that this bill is necessary to implement the 2008-2013 agreements, we are very concerned that the true purpose of the bill is to indemnify the federal government from legal liability for its mistakes during the botched enrollment process. It is this denial of legal recourse to applicants that is of the greatest concern to the Liberal Party. Clause 4 of this bill is clearly designed to shield the federal government from potential liability for damages flowing from their incompetence in implementing the original agreement. Clause 4 states, 4.1, no person or entity has a right to claim or receive any compensation, damages, or indemnity from Her Majesty in right of Canada. Any employee or agent of Her Majesty, a band, a council of a band, or any other person or entity, only because any person's name or any person's date of birth was admitted or removed from the schedule to the Qalipu Mi'kmaq First Nation Band Order. This limitation of access to a legal recourse is causing many to question the legitimacy of this bill. The repeated mistakes and oversights of the federal government through the process to create the Qalipu Mi'kmaq First Nation Band have led to unnecessary confusion and many applicants feeling frustrated and wronged by a process that should have fostered reconciliation about a historic wrong. The Mi'kmaq First Nations Assembly of Newfoundland is preparing to launch a class action lawsuit against the federal government over the constantly changing process for membership in this new band. The process in course seeks to remedy the damage done over centuries, but the mismanagement of this government exacerbates the feeling of victimization among many members of the Qalipu Mi'kmaq Nation. Claim against the federal government for mistakes or mismanagement should not have that legal recourse cut off by this bill. It should be for the courts to decide whether damages related to the enrollment process are appropriate, and not for parliamentarians to prejudge that issue with this bill. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires.